sounds quite logical, but you didn't put this evidence in. You were relying on the allegations in the complaint, correct?
Yes, but everything I've told you is in the complaint.
But the complaint doesn't say all of the things you just said.
It does, Your Honor.
The complaint says that if you keep the truck running, that the concrete won't spoil?
3.8 and 3.9 of the complaint, yes, Your Honor. And the other facts that I've mentioned to you today, in Washington, the complaint incorporates the declarations that Glacier itself admitted, and it also incorporates these so-called hypothetical facts, factual representations that Glacier made in its briefs. I have not mentioned a single fact to you today that is not either directly on the face of the complaint or incorporated into the complaint through Glacier's own declarations or through the
What do we do with their complaint that the truck was at risk the trucks were purposely put at risk to have the concrete harden and destroy the trucks?
Well, we know that the trucks were not in fact harmed, so that's one fact, and Glacier itself has pled that fact, which you just asserted. That's true. Glacier pleads that, but it also pleads several of the precautions that we took to avoid harm to the trucks. And so given the tension in Glacier's own factual assertions—
But I think the government's position is, if there is tension, it's your obligation to come forth with evidence under our command in Davis that you have to submit enough evidence to enable the court to find that the conduct is arguably protected.
And we're certainly allowed to rely on the other side's pleadings. In this court's decisions in Jones and in Curry, the court found—
So if the pleading is simply you did this intentionally at a time to ensure that that's how I read the pleadings. You did it intentionally at the time to ensure that the trucks— now you can argue all you want that you really didn't do that, but we have to accept the complaint as is, and I think it says that you did it intentionally at a time to blow up the trucks.
It says
that the likelihood was going to be great or was going to be great.
It says two things. It says what you just said, Your Honor.
Once it says that, isn't it enough?
No, because it also details in particular the precautions we took to avoid those very harms that it says we had in our head. So what it's alleging is we had a bad scheme in our head.
Well, there were at least 9 drivers that didn't tell their supervisors that the trucks were there running.
According to their allegations, that's correct.
But we have to accept that on its face.
Absolutely, but 90% of the—
So assume we get to where the SG is, which is on the face of the complaint, you didn't put in enough. What remains of your argument? Meaning, do we just reverse on— that's the ground that the SG is suggesting we reverse on.
So if you agree with them on the first position, then I still think you should either affirm because of the issuance of the general counsel complaint, which under Davis Supermarkets shows that the board has taken up the case and is currently exercising its primary jurisdiction.
Why should we make that decision? Why shouldn't the court below decide what it's going to do?
Well, one reason is I think it's fundamentally undisputed between the parties. The government and we agree here, and Glacier at Clerk's Paper 283 and 84 below relied on the same case, Loman's Plaza.
So why don't you put in evidence like the way Davis did?
Davis allows a party to either rely on the other side's admissions or—
Why aren't you doing that?
If we are remanded, we will certainly do that on remand, but just the other disposition, if you disagree with me that this court has, that it would be proper to address the significance of the complaint, the general counsel complaint in the first instance, I think a more appropriate disposition than a reversal is a vacatur with instructions to stay in light of the general counsel complaint. And the reason for that is that the government is essentially asking for an advisory opinion. It's asking this court to ignore current reality, and this court is often taught—
I don't know if it's the government. It's certainly your adversary.
Well, I think both of them are asking for a reversal is what I heard today. And so I think this court should not ignore current reality. It should take into account current reality, and it should decide the case on the narrowest grounds possible.